Good evening and welcome to Be Informed. My name is Carl Buhariwala and I founded Be Informed to help people make good decisions. Today we're looking at Family and Migrant Matters, and we are joined by Stephanie Vejar of Women's Legal Service Victoria, who will be speaking to us today about the intersection of family violence and temporary visa holders in Victoria. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to their elders, past, present and emerging. Today's session is being recorded, so if you do have to drop out, do not worry, you can watch the entire session on our YouTube channel following today's session. And the jurisdiction in which this session is being presented is the Australian jurisdiction. So if you are considering the relevance of this information for a jurisdiction outside of Australia, please do reconsider its applicability. And the state of the jurisdiction that we're considering today is Victoria. So I think I understand that the regime is different based on other states and territories within Australia, so you may wish to reconsider its applicability. And the currency of the information is as of the 16th of October. So please do bear in mind that the legal regime can change over time, so you might want to reconsider its currency in the future. From a housekeeping perspective, the session is being recorded, as I mentioned. There's also a one-page handout that will be sent through to registered participants. So you've got a handy reference after the closure of today's session. And if you do have a question, please raise it through the Q&A function, and I will then relay those through to Stephanie for her to answer during the Q&A session, Q&A part of today's session. So with all that in mind, I will now hand over to Stephanie. And please bear in mind, this is general information only. And if you do require any sort of specific personal sort of advice, to consult a professional in the space. Stephanie, I'll hand over to you.
Fantastic. Thank you, Carl. I would also like to start by acknowledging the traditional custodians of the lands from which I am presenting to you today. For me, that's the Wurundjeri people of the Kulin Nation. Pay my respects to elders past and present, and any Aboriginal and Torres Strait Islander people that might be with us today. I also want to acknowledge that the legal system is often a barrier for justice and is culturally oppressive for our First Nations Australians. So I acknowledge that the colonial structures and policies remain in place today and recognise the ongoing struggles of First Nations people in dismantling those structures. And I acknowledge that we participate in this meeting today on unceded lands, that it always was and always will be Aboriginal land. So today we're here to talk about the intersection of family violence and migration law. This is an area, my passion area. It is what the Women's Legal Service Victoria Migration Team is funded to do. And in particular, my work revolves around assisting women and children who experience family violence and are on temporary visas. So before I get into family violence and the dynamics, it's also important to note that the definition of family violence that I will be running off comes from the Family Violence Protection Act, and that is from Victoria. However, the Migration Act, because the migration law is federal, you will be looking at the family law definition of family violence in saying that there are sort of nuanced differences, but overall the same themes. It's also probably important to note that I will also be speaking about family violence with the gendered language, and that is to also reflect what is in the preamble of the Family Violence Protection Act in Victoria, in noting that although family violence can happen to anyone, predominantly it is perpetrated by men against women and children. So I will invariably use gendered language, but please do bear in mind that family violence can happen to anyone, and you apply it as need be on a case-to-case basis. So in terms of family violence, we've put a statistic here. So in 2021, the Monash University and Harmony Alliance found that 1 in 3 migrant and refugee women had experienced some form of family and domestic violence, especially with temporary visa holders consistently reporting proportionately high levels of family violence and domestic violence, including controlling behaviours. So when we're looking at family violence, there is a power dynamic immediately when it comes to visas. So often the person with the most power in a relationship can quite often be the permanent visa holder or the citizen, because they have more access to services, they understand the system. There are a number of power dynamic issues. So when I'm talking about family violence today, the definition is quite broad and it does capture quite a lot of types of abuse. Please note that each state does have variances in what they count as family violence, but in terms of migration law and what the Department of Home Affairs will view as family violence, it can include things like physical abuse, sexual, emotional, psychological, verbal, financial, or economic, anything that essentially makes you feel like you are walking on eggshells. So anything that has to do with living arrangements, visa issues, so threatening to withdraw sponsorships or essentially tell Home Affairs or have your visa cancelled, all of that can be considered visa abuse. There's quite a lot of cultural abuse that can occur, and that might be isolating you from your community or not allowing you to meet new community members, religious abuse, which might be preventing you from participating in your religious upbringing and cultures, and spiritual abuse. Community abuse quite often happens. That's quite isolating. So anything that isolates you from other people, from people that you would normally spend time with, and also threatening or coercive behaviours. Now, coercive behaviours can be, it's quite a broad type of family violence, but essentially anything that feels not quite right, makes you feel unsafe or uncomfortable and fearful of defending yourself against. So in saying that, any type of family violence that occurs, it also, if a child is caused to hear that, witness it, or be exposed to those actions, that is considered family violence against a child as well. Now, when we say hear, witness, or be exposed to, so they don't physically have to be present with you in the moment of family violence, but for example, if there's physical abuse, let's say there's a punch to a wall and there's a hole in the wall, and if that child is to wake up in the morning and come out of their room and see that damage, that in itself is family violence because they're being exposed to the elements of family violence. So it is really important that we look at family violence holistically and with a really broad perspective, because there are so many considerations when we're talking about family violence. Now, I'll go to the next slide. So in Australia, some visas have what we call family violence provisions. So that is an exemption process essentially for you to be able to continue with your visa process if you experience family violence. Now, if you experience family violence, you may be able to stay in Australia and continue on your visa pathway without a sponsor. When I'm speaking about this generally, a rule of thumb is I'm talking about partner visa applications. However, I will get into exactly what kind of visas can apply for this shortly, as we have had recent changes that have been quite welcome. And so when we're talking about family violence provisions, there are partner visas and a number of other visas that where you apply for a combined visa application. So that is that you would apply for both your temporary and your permanent partner visa. Now, if you apply for one of these eligible visas, there are three, so a partner visa, there are three reasons why you might still be able to get that visa granted, even if the relationship ends or the sponsorship is withdrawn. And those three reasons are that there is a child of the relationship, the sponsor has unfortunately died, or that there is family violence. So we'll be focusing on the family violence element. However, if your relationship ends and there is a child of the relationship and there is family violence, you can go down either pathway to establish why you are still eligible to be granted the permanent partner visa. Now, when the Department of Home Affairs is looking at granting someone or allowing someone to continue with their partner visa process, quite often to be granted that visa, they need to establish two main things. The first one is that the relationship was genuine, so that you were in a genuine either de facto or married relationship until it ceased because of family violence. So, and the second element is that the family violence occurred within the course of the relationship. So if your relationship ends and then many, many months later you experience family violence, or vice versa, you experience family violence, but then you start your relationship later, they will have some concerns around that timeline. So essentially, the evidence that you need to be providing or highlighting to the department would be that your relationship was genuine from the date of your application or the date that you mentioned that your relationship commenced until the date that you say it ceased, so the day that it finished, and that it finished because of the family violence. You will also need to provide information around that family violence, and I can walk you through those examples because there is a little bit to it. But that is sort of your rule of thumb when it comes to partner visas. Please bear in mind when I say partner visas, these are partner visas that you do with an Australian citizen or permanent resident. I know that the term partner visa can quite often be used incorrectly when describing a sort of a visa where you are a dependent for someone else. So this doesn't apply to those circumstances. So I'll jump to the next slide to be able to explain which visas this applies to. So as you can see, who can use the family violence provisions? So the first and the easiest ones to explain are the temporary permanent visa, partner visas. So that can be an onshore or an offshore application. Now, when I say onshore, that means inside of Australia, and offshore being outside of Australia. There's two separate categories for inside of Australia and outside. Then there's also what we call a prospective marriage visa. So often in relationships where you are engaged to someone who is overseas and they wish to come into Australia so that they can get married, that visa as well, you can access family violence provisions. So those first three listed there are probably the easiest ones to explain the family violence provisions with, because you have been sponsored by your de facto partner or your spouse, and you have said that you are in a genuine relationship in the prospective marriage visa case, that you intend to marry this person. And if you experience family violence from that person, you are still eligible to continue with your visa pathway. There are also provisions for dependent child visas and for global talent visas. Now, it runs the same way, essentially. If you experience family violence by the person sponsoring you, and in the dependent child's case, it would be the child, they can also access family violence provisions. Now, the good news is, since the 16th of October, secondary visa holders who have applied for the listed skilled visas that are outlined here on the slide can also access the family violence provisions. So there are very specific visa numbers. So if, for example, you are experiencing family violence and your husband or your partner has applied for one of these permanent visas and you are the dependent or the second applicant on that visa, if you're experiencing family violence by your partner, who's the main applicant, you can now access the family violence provision. So you can tell the Department of Home Affairs that you have been experiencing family violence and go through that process and hopefully be able to still be granted your visa. Now, the only reason that you might not be granted your visa is if the main applicant didn't meet the criteria. So it is a little bit more nuanced than the partner visa element, because the partner visa element for family violence provisions is show the genuine relationship and then the family violence. With the sponsored ones, they do take into consideration the main applicant and if they still meet the criteria to be granted the visa. But in saying that, they will again assess the genuineness of your relationship while you were the dependent in that visa application, and then that family violence was experienced. You might also note that the visas that have been listed here that are skilled, and there's not many, but they're all permanent residency applications. So it's really important to note that at the moment, the Australian government is really interested in extending the family violence provisions to most permanent residency visa subclasses. Now, this is a really big piece of work that they've communicated to us, so we have no idea if it's going to be expanded to any other visa subclasses. But from today and the day that I am presenting to you this information, that's the 30th of October 2024, in case anyone's watching this on YouTube later, these are the only visas that can access the family violence provisions. So that's really important. If you don't hold one of these visas but have experienced family violence, highly recommend you go to a migration lawyer or agent to get some advice about your independent visa options, because often if you don't have the option to use the family violence provisions and are experiencing family violence, it's so important to remember that the number one priority when we're dealing with this intersection of legal issues is that safety is the paramount concern. So that is always going to be our number one concern, that you are safe. So you can access family violence supports, grab a migration agent or lawyer and get some advice immediately, because your visa will quite often determine what services you can access. It will also give you a better idea of whether remaining in Australia long term is a viable pathway for you, and what's the best option for you. So just because your visa is not listed here, it's not a deterrent from getting any assistance. It just might mean that your visa pathway might not be as simple as using the family violence provisions. I'll go to the next slide. Thanks, Carl. Now, if you experience family violence and have applied for one of those visas listed in the previous slide, as I mentioned, you need to demonstrate the genuine relationship, and then you need to provide evidence of family violence. So to begin with, genuine relationships, it's not an exact science on how they assess it, but essentially there are 4 pillars that we try to assess people against, or Home Affairs assesses people against. So you want to show elements of your social aspects of your relationship, the financial aspects of your relationship, your household and domestic division arrangements, and commitment to one another. So things to establish your relationship would be things like photos with your family and friends. Financial aspects might be joint bank accounts, or even just evidence that you pay for things for each other. Household and domestic arrangements can be provided in a statement. You can just tell the department how you divide the household chores. So who takes out the bins, who makes the beds, things like that, who cooks, who cleans, just everyday things. Is you really need to paint a picture of the relationship, and then talk about the mutual commitment to each other. So that usually means sort of a bit of a background on how you met, how you fell in love, and then how the relationship progressed. Now, if you've already provided that information during your partner visa process, and now you're experiencing family violence and you would like to access the family violence provisions, the next thing that you will need to do is demonstrate that you have evidence of that family violence. Now, there are 2 ways to go about this. There is judicial evidence, so that is evidence from a court, or non-judicial, so non-court evidence. Now, there are 3 main things under the options under the judicial stream that you can demonstrate. And if you are able to give judicial evidence, you only need to provide this and nothing else. So an injunction under the Family Law Act, a court order like a family violence intervention order, has to be a final order, and I'll talk to you a little bit more about that later, or convictions or a finding of family violence made by a court, or an offence for family violence. So, but it needs to be a found offence now, and a conviction. So typically speaking, in terms of judicial evidence, the one that most people, if you're going down this pathway, that they can access easily is, especially in Victoria, is a family violence intervention order. Now, I've specifically said it needs to be a final order. That is because in Victoria you can have an interim, so that's just while they're making the final decision, and then you can have a final order. So that will be an order that has an expiry date. A court has assessed and decided, yes, you should be given this order to protect you from someone else, and will instruct you around that. But it has to be a final. So if you're currently in the process and you have an interim, but you don't know how long the court case might take, but you've got everything else ready, you might want to consider going down non-judicial. Equally, sometimes family violence can be so coercive and so limiting in your ability to find evidence of it that you might not have you might have gone to police and perhaps they haven't suggested to get an intervention order, or perhaps even just going through the process of getting an intervention order might be so traumatic or triggering that it's not the best pathway for you, especially if you are feeling safe once you've left the relationship and you're not being and you're not concerned about your safety, then perhaps a family violence intervention order isn't the best option, because we do need to weigh up safety planning. So are we going to aggravate the perpetrator more by getting one if they've left you alone? There's a lot to consider. A family violence intervention order isn't always the best option for everyone. And like I said, some people find the process quite draining. And yeah, so the other alternative, if you can't go through the court process to get an intervention order, would be non-judicial. Now, the first option there is a joint undertaking by a court, but I should say it's considered under non-judicial because it's not a final order found by a court. It is undertaking is essentially like a promise that you make with the other person to not commit family violence. So this happens quite often where there might be cross-intervention applications. So you might bring one to protect yourself against your ex-partner, and your ex-partner might bring one forward to protect them from you. And so sometimes people will come together and say, okay, well, let's just do a joint undertaking. We're going to promise to the court that neither of us are going to commit family violence. And that document in itself is sufficient for non-judicial evidence because it's not a final order from a court. It's just a promise to the court that's documented. Now, if you don't do an undertaking, the other way to do it is that you can complete a statutory declaration, a Commonwealth statutory declaration. Now, the Department of Home Affairs has a website that you can access, and it gives you a form that explains exactly what you need to complete in that statutory declaration. Essentially, you need to describe your experiences of family violence, when your relationship ended, why, and give as many examples of the family violence that you can. So essentially telling your story of the family violence. Now, if you do a statutory declaration, it needs to be witnessed by someone who can witness statutory declarations. So it needs to be an executed statutory declaration. And you need to provide at least 2 documents from the list of evidence that's specified by the Department of Home Affairs. Now, this list is quite broad. There's a few options, and fortunately, most of them are things that people can usually access. So it is really important that the types of documents that they suggest you can obtain, you can only get one from each category. So one of the categories is like a family violence crisis service. So if you've accessed crisis accommodation, you might have someone there write a letter to confirm that you've made disclosures of family violence, that you know who committed the family violence against you, give a bit of a, and say in their professional opinion that they think that you were the victim survivor of family violence. Now, however, if that person does it from there, you can't then get another worker to write another letter from the same service or from the same type of service. So you would then need to pick a different category. Now, there are different categories. So there's medical, so you could get a GP or a registered nurse. Quite often midwives will be registered nurses as well. You can get them to write you a letter, a statutory declaration, provide you a hospital report. There's a variety of documents that you can provide. Even your GP can write a letter. That quite often is the easiest one for people to access because most people have a GP on hand and can ask for them to provide that information in a letter. If it's for a child, schools can provide reports. Social workers, I highly recommend anyone who's experiencing family violence and is a temporary visa holder, especially given we know how many barriers that you experience, that you try to engage with some sort of specialist family violence service because they will often connect you to social workers. So selfishly, that means you can get a piece of evidence, but also it means that you have someone to hold your hand through this whole process because it can be so incredibly exhausting, and it's just nice to have someone to help you put some goals in place while you go through this process because it can be a little bit of a lengthy process. So essentially, if you can provide 2 bits of those evidences and provide a statutory declaration, you have completed your element of evidence of family violence. Now, I always recommend that you get a lawyer to do this. The migration system is made to be user-friendly, but I would say it is always best to get legal advice around this. Now, people who can provide you advice around this are migration agents and migration lawyers. They would be the people that you need to be approaching and asking for information about that. So you can, in the handout resource page that we've provided, there will be links to services. I highly recommend that you get in contact with the Community Legal Centre if you're limited on funds. Otherwise, the Law Institute of Victoria, you can go on their website and find a free referral service as well for migration lawyers to get a once-off consultation, or you can just Google someone if you can afford and to go to a private lawyer, because it is a really good investment to get the correct advice so that you can go through this process, given that it's quite specific about the kind of evidence that you can provide and the kinds of questions that they're going to ask. I'll go to the next slide. Now, on the flip side, if it's really important to understand how intervention orders can impact on temporary visa holders, especially either if you're the affected family member, so that's the person experiencing the family violence who needs protection from another person, but also on the flip side, I wanted to talk to you about what happens if someone says that they need protection from you. So the first part is the difference between the interim and the final intervention orders that I was discussing before. So as I mentioned, an interim is just when you are waiting for the process to finalise. Sometimes if you need immediate protection, the court will order what we call an interim intervention order. So there'll be no expiry date on that. It'll just be until the matter goes back to court. There will be a list of conditions, and that one basically just says that you're currently protected until we make a final decision. Now, when it comes to final orders, a court can either make a finding of family violence and you can come to a final order, or people often do what we call consent to having a final order, but they consent without admission. So that's just saying they agree to have a final intervention order against them, but they're not admitting that they've done anything wrong, and they're not confirming they've done anything wrong. Now, generally speaking, this is probably a good idea for some people, because when you're going through this process, you know, sometimes it's better to agree. It's a civil order, it's not criminal. As long as you comply with your order, it will disappear at the end of the expiry date and you're done. However, it is so important to know, if you are a temporary visa holder and you have a final order against you, so not protecting you, but saying that you're the one committing family violence, this can trigger a character issue with Home Affairs. So final intervention orders can be really helpful if you're trying to establish that you are the victim survivor of family violence, in particular in these partner visas or skilled visas where there are family violence provisions, and they ask for either judicial or non-judicial evidence. A final intervention order can be really helpful. But if you are on a temporary visa experiencing family violence, having a final intervention order, even when it says consent without admission, so noting that you haven't said that there is anything that you are admitting to doing, it can delay your process, it can delay your migration matters, it can cause concerns about your character, and essentially most people will be sent to the visa assessment character unit. So essentially the character unit will have a look at your visa and say, is this person of good character to be out in Australian society? Do we want them to keep their visa? Can we, do we want to grant them a visa? It does delay the process quite a lot. Just from my recent experience, it can be up to 12 months or more just waiting for that processing time. So it's not uncommon that it takes them quite a while to establish and confirm that they're happy for you to still either hold your visa or be granted a visa. So that's really, really important. It's part of the ministerial directions. So that is that the minister's focus recently was to make sure that anyone who's committed family violence is inspected quite heavily, because essentially Australia is saying that they don't want to tolerate family violence. Obviously, this is really hard because sometimes people can be misidentified as primary aggressors. So it's not uncommon for a temporary visa holder to experience systems abuse. So that is when I was talking about those power dynamics at the start. We want to make sure that you understand that you have the right to be safe and you have the right to go to the police and report, and no one can cancel your visa apart from Home Affairs. So if a sponsor is telling you, if you don't do X, Y, Z, I will have your visa cancelled, or if they go and try to use the system against you, that's systems abuse. And often this is where misidentification can happen, and it's so important to access either a duty lawyer service at whatever magistrate's court you might be at, getting some family violence lawyer advice wherever you can, just because your temporary visa can be quite dependent on the outcome of these matters, and you want to make sure that in the eyes of Home Affairs, that your character remains unblemished as much as you can. It is a really hard thing to tell people, that you can't make any mistakes while you're on a visa, because it's so unfair to expect so much of particular people, and sort of have a different system for temporary visa holders versus citizens and permanent residents. But essentially, if you are ever experiencing misidentification, work with a lawyer as soon as you can. And if you are in the process of family violence proceedings, so if you are the respondent, so that is the person that they're saying is the aggressive person, please work with a migration lawyer as well as a family violence lawyer as soon as possible. At Women's Legal Service, we have a holistic approach. So we have family violence lawyers as well as migration lawyers, so we can help people. But often services can work together. So maybe one community legal centre is helping you with your intervention order, and you might have a private migration lawyer who had been assisting you with your visa application. So just make sure you get your two lawyers to have a chat to make sure that whatever decision is made at court doesn't negatively impact on your visa. And vice versa, I think it's really important sometimes that while you're talking to your migration lawyer or your family violence lawyer, that you mention that they are working for you both at the same time, so that way you can put them together and then they can work together to come up with the best outcome for you. Because if safety is the paramount concern, both of them need to start from that point and then work on what's best for you next after that. So I thought it was really important just to highlight that for you all, but hopefully I think it's time for questions.
Thanks, Stephanie. No, that's a very comprehensive seminar, so I hope those that have attended today have definitely taken away some tips and traps that they should be aware of. I'll share Stephanie's details on screen, so if you do have any further questions or wish to discuss your circumstances with her, then you can contact her directly. Her details are on screen. So just a reminder, this session is being recorded, so if you have joined late, that's fine. You can watch the entire session on our YouTube channel following today's session. And Stephanie's also kindly prepared a one-page handout which summarizes the key sort of elements of today's seminar, and you'll get that by email for those who are registered. So we'll now jump into the Q&A component, Stephanie, and I think one of the first questions that we've got ahead of time, and then we'll jump to some of the questions that have arrived through the Q&A function. You mentioned that, of course, when you are experiencing family violence, engage a professional as early as possible. I guess most might not be too familiar with, the family violence provisions that may support them with their visas. In your experience, for those that have come late to you or to a lawyer, can the process be expedited if they are facing a situation where the temporary visa might expire? Sort of what, I guess, leverage does the Department of Home Affairs have when individuals come a bit late to the party when they're trying to protect their visa?
Yeah, that's a really good question. Unfortunately, migration law is one of those laws that's really inflexible, is probably the best way to describe it. So the later you come to the party, the less likely you are to get a good outcome. And that's not because you're less deserving, it's just because there are time restrictions, there will be refusals, there are appeal dates, there's a lot of planning that goes into it. So essentially, as long as you still hold your visa, nothing's been refused yet, just try to get to a migration lawyer as soon as possible, or at the very least, put the Department of Home Affairs on notice. There is a domestic and family violence support unit that we quite often work with that anyone can access. The details are in that handout. And quite often, if you notify them that you are experiencing family violence, they can also give you resources on where you can go to get some advice immediately, or at least tell you, if you have days to react, or if your visa's already been cancelled, or they can give you some more information about your circumstances, and they're more likely to be able to advocate internally for you. So it's not the end of the road if you come to us late. It just does make it a lot harder. And in saying that, advocates will always advocate for you. That's what our job is. But the earlier, the better.
Thanks, Steph. And just a quick question about how it works with Women's Legal Service, right? If someone does come to see you, I guess there's sort of an eligibility assessment, and then could you just quickly summarise whether there's any costs involved? Which had a specific query about your services, Stephanie.
Yeah, so Women's Legal Service runs like most community legal centres in that our legal services are pro bono, so we don't charge people for our legal services. The portion that would that sometimes people have to pay out of pocket is if there's any external expense. So sometimes if you come to us and you need us to lodge a visa for you, if that visa comes with a fee, then often we will tell you that you're responsible for that fee. That will be told to you up front. And in saying that, if you're going to a community legal centre, quite often that is because you have sort of a lower income or are struggling to support yourself. And in that case, quite often, if you're connected to family violence services, sometimes they can also get the funding for you for those expenses. So it's not uncommon for me to work alongside social workers who are incredible angels who can find funding from family violence services when we need it for an emergency visa application fee or something. So apart from those external fees, you won't be experiencing any cost from us.
Thank you. And Steph, just on timing, so just had another query about, if someone were to come to you seeking your support to, I guess, activate one of the family violence provisions, if you have like a recent, anonymous, of course, client that you've supported, sort of what's rough timelines that people are looking at? I know you've given a bit of an indication it does take time for the process to work through, but are you able to sort of just share a bit about what that looked like and what the timings look like if someone were to come to you, say, today?
Yeah, it is a little bit hard to comment just because Home Affairs, because it's a government body, it quite often will fluctuate in its processing times. So not only in its visa processing times, but in its family violence provisions processing time. So there's no actual sort of timeline on how quickly they will process family violence provisions for you. However, our experience has been that it has changed most recently, and whether or not that's because we're coming up to an election, that could be it. Quite often government bodies sort of slow down a little bit. There has been reshuffling, politically. So often what's happening in the political climate impacts on timelines for us as well. If someone comes to me today and says, look, I need to access family violence provisions, I applied for an onshore partner visa, I'm experiencing family violence, my immediate reaction would be, okay, let's get you let's tell the department what's happening. Let's start gathering up your documents, go to the GP next week and ask for a letter. Let's get you talking to the social worker and get a letter from them, however long it takes. And then, submitting that to the department will depend on how hard it is to gather that information and, preparing a statement. It's really important at Women's Legal when we're doing these kinds of statement appointments, if it's really raw and quite, we want to make sure we do it in a trauma-informed way. So if doing an appointment for 2 hours where you talk about all of the family violence you've experienced is too much, we can break that up. We can start getting that information from other ways and then present it to you and have you help us prepare the statement when you're in a better state of mind. It is very much a holistic approach, and that is always the best approach because the system itself can be quite re-traumatizing because they will ask a lot of questions. So as practitioners, it's really important that we take our time to do that. So it's not so how quick we get to them, it's more about how quickly you get to a lawyer, because the lawyer can help get you extensions of time, they can help you gather that information and just put you on the right course on what you really need to be doing next.
Yeah, and Steph, just an extension of that, sort of how well do you see the Department of Home Affairs in applying these provisions? Are they pro, depending on the circumstances, granting, the necessary sort of protection, I guess, from a permanent visa perspective, or are they a bit more skeptical and will ask a lot more questions? Like, what's sort of your take on your experience with supporting your clients on that front?
It's definitely different on a case-to-case basis. So when there is a really short relationship, sometimes they have a few more questions, or if the reporting comes late, which we know is really common, where you might experience family violence for a long time, you might flee, and then much later down the track go, okay, I'm out of survival mode. What do I need to do next? Oh, I need to deal with my visa. And then you go and report it months and months later. Sometimes they do have more questions about that. But overall, Home Affairs, as long as you're providing them the information that they want in the format that they want to see it, so that's why it's important to work with a lawyer, because we know exactly the way they want to see it and what they want to read. So we can best advocate for you. Once you've provided them all of that, then generally speaking, it's, we have really great outcomes at Women's. It's just dependent on the relationship history. There are other sort of issues that can come up in migration law, whether your relationship timeline makes sense, whether there's you've met all the other criteria. So there is, things that you should have met at the time that you applied versus things that you need to meet when you at the time of the decision of the visa. But overall, I say I have noticed that Home Affairs, ever since the inception of our pilot program, they created the Domestic and Family Violence Support section. They are definitely interested in working alongside, in particular, practitioners to best support victim survivors of family violence who are on temporary visas and are trying to access the family violence provisions to get their visas. So they're definitely flexible. They give extensions. They are, overall, I haven't had a bad experience so far doing this process with Home Affairs, especially when you engage the Domestic and Family Violence Support section.
Mm-hmm. That's good to hear. And just should an applicant not agree, I guess, with the approach taken, I guess this would be sort of administratively merits review type appeal. Are you able to share, Stephanie, sort of what might happen should, and does Women's Legal support in that respect, an applicant not agree with the, maybe they get denied the permanent visa, what sort of next steps looks like, just at a high level?
Yeah, so if any visa is refused when you've applied for one onshore in Australia, your next step is to appeal it to the Administrative Reviews Tribunal. So it's just changed from the AAT to the ART. But essentially it's a tribunal. It's a fresh look at your application. So they're looking not necessarily about the errors that the Department of Home Affairs might have made. They're just looking at the actual whole application, whether you meet the criteria, whether you should have been granted this visa, or if you meet the criteria and should be sent back to Home Affairs for them to give you the visa. It's a really, I find that the tribunal process, especially when there are bad decisions, sometimes there are just decisions made where you just don't agree with them and you can see the errors and the flaws in the decision making. At the tribunal stage, it is a bit more holistic. You can provide more information, you can provide more submissions, you can do whatever else it is you need. So that is definitely a process. It's important to note that there is a fee with the tribunal though. So if you are experiencing financial hardship, the only reduction you can get is maximum 50% of the fees. So the current fees will be up on the Administrative Review Tribunal's website. And that can change as well over time. But overall, there are appeal options. So if your visa is refused because either you didn't meet the criteria or they had concerns about the relationship, if that happens, the one deadline that we really can't change is if you miss the deadline for appealing to a tribunal. So we really recommend is if you ever get a refusal, look at the letter. It will normally tell you how many days you have to appeal, and within that time frame you need to either apply for the appeal, or as soon as you get that refusal, go to a migration lawyer. That will be the best investment you ever make, because those appeal deadlines really can't be moved. So that's the rule of thumb. Don't ever miss an appeal deadline. So everything else can sort of be chopped and changed and fixed if you can, but not appeal deadlines.
Yeah. And the submissions that are made to, during the process of seeking and, during the process of applying the family violence provisions and then seeking the permanent visa, of course, you've mentioned this is, a bit of evidence that needs to be submitted and documents gathered. And of course, ensuring the truth in those statements is definitely of paramount importance, given the government's going to be relying on that in their assessment. Have you ever had a situation, Stephanie, where permanent visa has been granted, or there's been reliance on those provisions, but the government has later changed their mind or has revisited some of the documentation provided and has questioned whether it's accurate or truthful and the like, or do they stick by their decision and that's fine?
Yeah, so once you're granted permanent residency, it's really unlikely they're going to be reviewing that. In terms of when I was talking about if you get an intervention order against you and they have character concerns, character is a really broad migration topic, just because if you hold a permanent visa or a temporary visa, any sort of visa, basically if you're not a citizen, character can become a really big issue because your visa can be cancelled if it was granted on the wrong grounds, if you gave wrong information. So this quite often happens where, for example, you've incorrectly provided information maybe about your work history, maybe about your family makeup. In these kinds of cases, it might have been you were actually not in a genuine relationship and it was contrived, or, these kinds of things can come up. And essentially anything that might lead to visa cancellation is another one where I go, that has to go to a migration lawyer or agent immediately. Cancellation or character issue matters are so time sensitive. So I'm not talking a couple of weeks like, if you get a request for further information, that might be 28 days with an extension option. When you're talking about character issues, you're talking about, 5, 7, 7 working days, 14 working days. It's really time sensitive. So given that it's not a lot of time, anytime, if there's any concerns about your character or about cancellation or notification of intention to consider cancellation, anything to do with character, get yourself to a migration agent or lawyer, even if it's just a once-off appointment, so they can give you an understanding of how to react if you get a cancellation notice, or if you've already got one, what you need to do next, because that again is a really sensitive topic with migration. And like I said, migration law is not particularly flexible, so it's very reactive. So quite often you need to get on top of things as soon as you can.
Beautiful. The final question, the tests that we've talked through, is that for family violence provision when you apply those, Stephanie, is that the same for all visa classes that are eligible, or do some visa classes have additional sort of requirements that may need to be considered on a case-by-case basis?
Yeah, so that two sort of limb test of being in a genuine relationship with that person and then and it ending because of family violence, and that the family violence occurred in the relationship, that extends to both the partner visa or sort of family visa people who could apply for family violence provision. So the first half of that slide, and then the second half being the skilled cohorts, it also applies to that. The difference in those two, the family violence provisions element goes through the same way. The difference between them is that the skilled one is that you're essentially the visa it's with the partner visa one, the family violence provisions is being done because you're experiencing family violence by the sponsor. In the skilled cohort, it's that you're experiencing family violence from the main visa applicant. So, and that they need to still be able to be granted that visa. If they're not granted the visa because of character issues relating to family violence, that's not an issue. You will still get your visa even if they don't. But essentially, if they're a skilled visa applicant and for whatever reason they don't actually meet the criteria for that skilled visa for the permanent residency, then that creates an issue because the family violence provisions might get up, but they still need to meet that criteria. So if you're a skilled visa holder, a temporary skilled visa holder, you're the secondary on it and you're waiting for that grant and you're experiencing family violence by the main applicant, it is really important to try to get the advice around that, because you also need to, one, go get safety plan and everything, but two, you also need to get a good idea of whether it's likely that you will be granted that visa or not. So this, because the changes came in so recently, that is our current understanding. It is very likely what happens when they make these changes, that they will continue to provide further explanatory memorandums to give us a better idea, or make little tweaks to make sure that it is viable for everyone. But yeah, it's really great to see that they're extending the family violence provisions to other permanent visa skills and subclasses, because as we know, family violence can happen to anyone. And just because you're in a relationship with, I don't know, an in-need engineer, it doesn't mean that you're not likely to experience family violence. So, you know, it's really important that everyone can access it. And we're really excited and hoping that they extend these further over time. We're not sure how long it'll take, but we've got our fingers crossed, and we'll keep pushing the department to push these through too.
Thank you so much, Stephanie. That brings us to the end. I'll just share Stephanie's details again. So if you do have any specific queries or wish to discuss your circumstances, please contact her at the Women's Legal Service Victoria. Thank you, Stephanie, again. That was a great session. I think we've had some great engagement as well with participants. Just a reminder that this session is being recorded, so if you have joined late, you can watch the entire session on our YouTube channel following today's session. And there's a one-page handout which I'll be sending through to registered participants by email. So thank you for attending a Be Informed session. Please do follow us on social media and through our Eventbrite account and on YouTube. I funded I found Be Informed myself and also funded myself too, so it's just me, and I do this just to make sure that there's good information being spread in the community and getting like-minded people like Stephanie, and of course experienced people like Stephanie to share important information that is of use and of need to those in our community. I hope you found this useful. And if you want to catch up on other sessions that have been around on Be Informed, you can go on our YouTube channel, and if you want to register for any upcoming events, you can go through the Eventbrite channel and subscribe there. So thank you all for joining us today. Again, thank you, Stephanie, for your time.
Thank you, Carl, and thank you to Be Informed for all the great work that you do. It's so important to get this information out there, so thank you for that. Much
appreciated. And just one last thing, I think there was a query around whether or not this can be claimed as a CPD session. I think the answer is no. I'm not affiliated with any professional group, so I think this information is just general information only. And if you do wish to claim a CPD point, you may wish to join another organisation that allows for that to occur. All right, bye for now. Thank you all.
Thank you.